Welcome, everybody. Welcome to the Law of Self-Defense live show for, I guess it's February 27th, 2022. We're here today to talk about the Breonna Taylor shooting trial, although, in fact, this trial has little or nothing to do, actually, with Breonna Taylor. We'll get to that. But this involved the shooting back on March 13th, 2020, so a bit almost 2 years ago. In which police executed a search warrant on the home of Breonna Taylor, in the course of which gunfire was exchanged. She was killed by police fire, and one of the officers involved in serving that warrant, who fired shots, has now been indicted, charged, and is currently on trial, but not on trial for the killing of Breonna Taylor, interestingly enough. So we're going to discuss that today. I'm trying to see if we can get a bunch of our different streams going today. So it's still a bit of a technology demonstrator. Wow, looked like it worked. So let me try some comments, some chat backs here. Make sure everyone's hearing correctly and so forth. It looks like our membership feed over at Law of Self-Defense is running correctly. It looks like our YouTube feed is running correctly. Hey, everybody on YouTube. Welcome. Hopefully that works okay. And finally, we're also trying to stream to, all right, to Rumble. That looks like that's working as well. I can't believe it. We got a little control of technology, at least for today. So that is absolutely awesome. As always, we will be answering comments as they come in, but this is the prioritization. We'll answer our Law of Self-Defense members' comments over on the membership dashboard first. Then we'll answer super chats on YouTube. And then, if possible, we'll get to Rumble comments. I'm not quite sure exactly how Rumble comments work, but we'll see what we can do with regard to that. So we have quite a bit of content to cover today. It might be a couple of hours worth. First, I'd like to cover kind of a background of what happened in the around the events that led to the death of Breonna Taylor, what's happened since then. Also step through the relevant Kentucky law, both the criminal charge and the legal defenses that will be available to that officer, and whether or not it seems likely that those defenses are viable. As part of that, I'd like to watch with you the opening statement of the prosecution as well as the opening statement of the defense. That's about 50 minutes in total of opening statements. The defense opening statement's only about 10 minutes long. So that'll tell us what the narrative of guilt and the narrative of innocence are for each side, and I'll comment on those as we go through. I have not seen those myself, so it will be as new to you as it is to me. And then there was also an interview done with the police officer charged in this case a couple of weeks after the event at the police station by essentially, you can think of it as kind of an internal affairs function of the police department. They have their own particular name for it. They're in Louisville, and this happened in Louisville, Kentucky. So we'll hear his words, his explanation just a couple of weeks after it happened. Now, he is present with counsel. And I haven't heard that interview either, although it was played in court late last week. This trial has been in progress over the course of the last week. Of course, we were covering the Curtis Reed's trial live, so this is the first opportunity I've really had a chance to take a look at the trial proceedings of this Breonna Taylor shooting case. So in a certain sense, I'm coming up to speed just like all of you are. The interview video is actually, I'm still producing it on my end. So as we're doing other stuff, that'll be happening on my second computer, and hopefully we'll get it up and running before the close of the show. If not, I'll likely cover it in a future show. But that's kind of the plan. That is about an hour-long interview. So just the video I'd like to share with you and comment on is close to a couple of hours by itself. So we could be here a while. So make yourselves comfortable, get a drink, get a snack, and let's enjoy ourselves. Yeah, I mean, the defense opening being 10 minutes doesn't really surprise me. It's a very straightforward defense. I think either the jury's going to buy it or not buy it ultimately. But we'll see that as we go through. So, a quick overview of this case. So, on March 13th, 2020, just about 2 years ago, police had a search warrant for Breonna Taylor's boyfriend, whose name I forgot to write down. Let's see. Doesn't really matter. What was his name? Kenneth, looks like it was Kenneth Walker. So the police had a warrant for Kenneth Walker, and that warrant was addressed to Breonna Taylor's apartment. So the police were sent correctly. I mean, they went to the right apartment. It's not one of those cases where the warrant was served at the wrong address. They went to the correct address. And the reason they were seeking Kenneth Walter and had a warrant for his arrest is one, he wasn't making his court appearances, and two, he had pending charges of both drug dealing and some gun charges as well. And the drug dealing charges, I mean, the police had more than probable cause that he was engaged in drug dealing. Plus, they also had probable cause that Breonna Taylor was an accessory in that drug dealing. For one thing, he was at her apartment, living, working out of her apartment. His bank accounts were in part controlled by her, and these bank accounts contained large sums of money for which there was no apparent source other than drug dealing. There were phone taps where he was telling other people that basically she was a co-conspirator in his drug dealing enterprise. But strictly speaking, the warrant was not for her, it was for him. I believe the intention of the authorities were to be to charge her as an accessory after he'd been arrested. But as it happened, the police got to the door. Now, it was a no-knock warrant in that they were authorized to go in without prior notification. This is very common in drug cases because the authorities don't want the suspect to have the opportunity to flush drugs or whatever down the toilet as they're breaking in the door. So often they don't knock, they don't notify before they go through the door. In this case, however, there was evidence from neighbors of the apartment that they heard the police notify before they went in. So although it was a no-knock warrant, it was not served in a no-knock manner. There was notification. Now, Kenneth Walker would later say that he did not hear this notification, and that could be true. Who knows? That happens sometimes. In any case, when the police went in, kicked in the door, or rammed in the door, whatever the case might be, Kenneth Walker, armed with a firearm, engaged those officers with gunfire. He shot one of them. The round struck that officer in the femoral artery, and his life was saved only, of course, by emergency surgery, but it was saved. Otherwise, it certainly would have been a fatal wound to Sergeant Mattingly, one of the three officers serving the warrant. In response to the gunfire, all three officers returned fire at Kenneth Walker. Sergeant Mattingly fired 16 times, even though shot in the femoral artery. Another officer, Cosgrove, fired 6 times. And the officer being tried in this case, Hankinson, shot 10 times as well, all into the apartment. So they returned fire, and some of those rounds struck Breonna Taylor. Now, life being what it is, ironically enough, Kenneth Walker, the person firing at the police, was not hurt at all. But rounds struck Breonna Taylor with fatal effect. So she was killed by the police return fire. And incidentally, because each of the officers had different weapons, we know that the officer on trial now a former officer, he's been fired shortly after this event, but the officer on trial now, none of his rounds struck Breonna Taylor. So he did not kill Breonna Taylor. Accordingly, he's not charged with the killing of Breonna Taylor. So when I said earlier that this case really has little or nothing to do with Breonna Taylor, that's because none of these charges involve any harm to Breonna Taylor. So that's why a lot of people were outraged that there were no murder charges brought here, because, of course, the outrage is over the notion that Breonna Taylor didn't have to die. She didn't deserve to die. This is somehow a wrongful death, and therefore there should be criminal liability for her death. In fact, the officers whose rounds did strike and kill Breonna Taylor, their conduct meets all the conditions of a justified use of defensive force. So they were not charged with any crimes, much less the unlawful killing of Breonna Taylor, because their use of force was not unlawful. They were firing in defense against the incoming fire of Kenneth Walker. Now, Kenneth Walker, for his part, would say that, well, he didn't know these were police. He thought this was some kind of home invasion. And one of the Kentucky statutes we're going to go over is a defense of highly defensible property statute, which at least nominally would apply in this case. We'll talk about that when we get to that statute. Kenneth Walker would say he didn't know it was police. Ultimately, I believe all the pending charges against him or any charges related to this event were dismissed on that basis. Also, of course, as part of the outrage over the death of Breonna Taylor. I had invited some of the law tubers to join if they wanted to, and I should keep my StreamYard tab open for that purpose. So those two officers, Mattingly and Cosgrove, were not charged with any crime at all. Hankinson was, and we'll get to the specific charges that were brought against him in a moment, but none of them had to do with the death of Breonna Taylor. So this case really has nothing to do with the death of Breonna Taylor. And there were a lot of shots fired. There were 32 shots fired. Again, 6 of those by Cosgrove, 16 of them by Mattingly, who'd been shot in the femoral artery. Neither of them were charged with anything, although their rounds did, in fact, kill Breonna Taylor, at least one of them. And Hankinson fired 10 times. So really, he was kind of the median between Cosgrove firing 6 times and Mattingly firing 16 times. Hankinson fired 10 times, kind of almost an average between the two. But the circumstances of his firing of his shots, the state argues, are sufficiently distinguishable that he ought to face criminal liability for firing those shots, even though he didn't actually hit or hurt anybody with his gunfire. So what more do I have to cover there? He would later be fired. The police department said his firing of 10 rounds into the apartment, so not like randomly down the street, but into the apartment from which gunfire was coming, that firing of the 10 rounds was unwarranted, basically. And so he's facing charges because the use of his force, the state says, is alleging, was unwarranted. This did go before a grand jury. Grand jury did return an indictment on these charges, and the charges are for wanton endangerment, what most states would call reckless endangerment. If that term reckless sounds familiar to you because you've heard it 10,000 times from the Kim Potter trial, this gives us another opportunity to distinguish between negligent conduct and reckless conduct, and as a consequence, the kind of legal defenses that can be raised for each. So Hankinson, the defendant here, is charged with 3 counts of wanton endangerment or reckless endangerment. We'll look at that specific statute in a moment. That is a Class D felony in Kentucky, and Class D felonies are good for 1 to 5 years in prison. Normally, under these kinds of circumstances, if he was convicted of all 3 counts, they would be served concurrently. So he'd be looking at a maximum of 5 years. Given the political dynamics of this case, it's possible the judge could sentence him sequentially. Frankly, that might likely be reversed on appeal, but the judge may attempt to use their discretion to sentence him consecutively, which would mean he'd be looking at up to 5 plus 5 plus 5 equals 15 total years in prison. So that's where we are with that. Now, let's take a look at the actual criminal charge here, the wanton endangerment in the first degree. Let me see if I can pull this up. And actually, before I do that, let me take a quick look, see if we have any questions already. Someone has a leftover Reeves question. All right, Miles Dog. He asks, is magnified, annotated, or looped video admissible in court? It can be. It's up to the judge. Is it more probative than it is prejudicial? Then the judge would likely admit it, assuming, of course, it's a fair and accurate representation of the actual event and all the other rules of evidence that would apply in court. But there's no reason it would be automatically inadmissible. All of any modifications would have to be transparent and explained to the jury. And let's see if we have any super chats in yet. Not yet. We're all good there. All right. So let's take a look then at the actual statute, the criminal charge, which for some reason I have trouble with this guy's name. Hankison, Hankison, Hankison. So I'll pull this up. Let's see. Share screen. Share tab. Here we go. See if I can make that a little bigger. Okay, so this is Kentucky Statute 508060. And by the way, folks, for any of these statutes, if you'd like to look them up yourself, or if you're listening to this as podcast content, you can always just type in lawofselfdefense.com/ the statute number without the dot in the statute number. So technically, this is 508.060. But if you type in your browser lawofselfdefense.com / 508060, it'll pull up this statute for you. So that should make it easy for you to access if you want to in the future. And 508060 is wanton, what most states would call reckless, endangerment in the first degree. And it reads, a person is guilty of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to the value of human life, he wantonly engages in conduct which creates a substantial danger of death or serious physical injury to another person. And second paragraph, wanton endangerment in the first degree is a Class D felony. Again, that's good for 1 to 5 years normally. And he's facing 3 counts of these. So presumably the state's arguing that he wantonly endangered the lives of 3 different individuals in the 10 shots that he fired. Now, this whole manifesting extreme indifference to human life and the wantonness, this presumes the lack of justification. If something is legally justified, it's by definition not wanted. And justification is going to be the primary legal defenses in this case, I expect. I guess we'll see when the defense makes their opening statement what they're arguing for. But that would be my expectation, because under Kentucky law, justification is a legal defense to really anything. Certainly any use of force charge, including wanton endangerment. And it could be a variety of defenses. It could be the justification of use of force in self-defense. It could be justification of use of force in defense of others, that he was defending his fellow officers with him. It could be the justification of use of force by a police officer, which actually has some different conditions than straightforward self-defense. We're going to look at all those statutes under Kentucky law, but those are the defenses I would expect him to raise. There are also some other justification statutes under Kentucky law that are interesting for this discussion, not so much because they apply to him, but because they apply to the boyfriend against whom he was attempting to direct his fire. Specifically defense of property and defense of highly defensible property, which creates a legal presumption that the boyfriend had a reasonable fear of death or grave bodily harm in defending his highly defensible property against an apparent intruder. We'll step through that. There are exceptions for when the intruder is a law enforcement officer, by the way. So we'll talk about that as well. And it's also notable because as a side note, the city of Louisville has settled with the Breonna Taylor family. They did so quite some time ago for the sum of $12 million to settle a wrongful death suit. But I don't believe the family has yet to sue the officer personally. One reason for that is they may simply be waiting for a hoped for guilty verdict in his criminal trial, because that would lock up civil liability. But also, Kentucky is one of the states that has a self-defense immunity statute where if you sue someone in a use of force event and they're able to prove that their use of force was lawful self-defense, you become responsible for their legal expenses in defending against that suit. So the family may not want to run that risk. They may want to wait, see if they get a guilty verdict in the criminal trial. And if so, it's really beyond question that the officer has civil liability and that it was not lawful self-defense. And therefore, they wouldn't be at risk of the having to cover legal expenses under the self-defense immunity statute. We'll take a look at that statute as well under Kentucky law. But the key legal question here is going to be, was the firing of those 10 rounds by that officer, was it reasonable and justified under the circumstances? If it was, then it was not wanton conduct. And whether or not it was justified is going to depend on the language of the justification laws we just mentioned, which are pretty standard language. There's nothing unusual in them, as well as how the jury interprets reasonableness, because a big part of reasonableness here is going to be, was that use of force reasonable for a law enforcement officer with this defendant's experience and training? For example, it'll seem pretty apparent, I think, that when he was firing his rifle into the apartment, he did not have an actual distinct target he was shooting at. He was shooting more or less at muzzle flashes inside the apartment, at the gunfire coming in at him and his two colleagues. Is that sufficient to be reasonable and justified? When you're taking incoming fire and you have a general sense of where that intaking fire is coming from, but you don't see an actual human body, which appears to be the case here, maybe by definition, maybe he's been trained that you never do that, in which case it would almost by default not be reasonable and justified conduct, would qualify as wanton, and that would pretty much be it. But that's the legal question here. There's a lot of facts and frankly claimed facts around this case that actually have nothing to do with the legal merits of this trial. Whether Breonna Taylor was a co-conspirator in her boyfriend's drug dealing enterprise, whether he was in a drug dealing enterprise, whether he heard the police announce, whether he had a reasonable, if mistaken, belief he was being subject to a home invasion, whether the other officers' firing of shots was lawful, because it almost certainly appears so. The fact that Breonna Taylor died as a result of the other officers' rounds, none of that has anything to do legally with this particular trial of this officer. Now, it may have a lot to do politically with the reason he's being charged. Certainly, the case has the feel of people are unhappy that Breonna Taylor died. They're getting the usual kinds of media propaganda that we expect in these cases. Of course, I haven't said it. It shouldn't matter. But of course, this is the world we live in. Breonna Taylor happens to have been a young black woman, and these officers are all white men. So we have another white cop on black suspect or black bystander death in the execution of a warrant that's been characterized technically correctly as a no-knock warrant, which of course people don't like. I don't like no-knock warrants either under almost any circumstances. So there's enough here to build kind of a robust propaganda view of this case. But most of the things that are part of that propaganda stew have nothing to do with the legal merits of this case, probably won't be argued in the actual legal merits of this case, which means we could end up with a verdict that's consistent with the legal merits of this case, but completely inconsistent with the propaganda, in which I would make sure that your homeowner's fire insurance was paid up if you live in the Louisville area. So let's see what else we have. So this is the criminal charge: wanton endangerment, what most states would call reckless endangerment. Now, remember, recklessness is a particular state of mind. Recklessness requires that you knew you were creating an unjustified risk of death, and you did it anyway. And then, of course, if someone died, it would be reckless homicide or a form of manslaughter. Here, nobody died, so it's not the actual harm that's the basis of this charge. It's the danger of harm that was created. He wantonly engages in conduct which creates a substantial danger of death or serious physical injury. Now, because this is wanton or reckless, the creation of that danger has to be intentional. He has to be aware he's doing it, and then he has to do it anyway. Now, unlike the Kim Potter case, Kim Potter, all the evidence, it was uncontested that Kim Potter did not know she had a gun in her hand. She did not know she was creating the underlying risk, which is why her conduct should never have been characterized as reckless. Negligence, fair enough. Negligence merely requires that you should have known you were creating a risk, but you were not intentionally creating the risk. Recklessness is where you're intentionally creating the risk. Now, on these facts, it seems clear that either this conduct is justified or it's reckless, because there's no misconception here. He's not saying, I didn't know I had an AR rifle in my hands. I didn't know I was firing it, as was basically the circumstance in Kim Potter. He's obviously concedes knew he had a rifle in his hand, knew he was firing it. So there's no negligence here. There's no he should have known. He definitely knew. Now, perhaps that conduct, his firing those 10 rounds, was justified under the circumstances. We'll look at the justification statutes in a moment, in which case it's lawful and there ought be no criminal liability. But if it wasn't justified, wasn't reasonable, wasn't non-reckless under the circumstances, then it was reckless. And he would seem caught up in this criminal statute. So that's the criminal charge. Now I'm going to want to step through. It's a little tricky going from screen to screen. Now that we've done that, let me take a look again at the comments here. I want to make sure I kind of stay. Oh, that's inconvenient. When I enlarge, it enlarges everything. Go back here. Let's see. Ryan Clark writes, there was an excellent long-form interview with Officer Mattingly. Officer Mattingly was one of the officers involved in this service of the warrant. He was the one that was shot in the femoral artery, whose life was saved by surgery, who fired 16 times, returning fire at Kenneth Walker. It says, excellent long-form interview with Officer Mattingly on the Cleared Hot podcast by retired Navy SEAL Andy Stumpf. I have to confess I'm not familiar with that podcast, but certainly I now that I know it exists, I'll plan on certainly listening to that interview. Says Ryan writes, it's a great take and dispels a lot of information. That would be super interesting. I know at least one of the other officers involved has taken the Fifth Amendment and is declining to testify in this case. Of course, the other officers, while they have not been criminally charged and ought not be criminally charged on the facts of this case, the two that fired at Kenneth Walker and whose rounds, at least one of them rounds, struck and killed Breonna Taylor, their conduct was clearly justified under the circumstances. But anytime there's public ire at these type of events, especially these white cop shoot black suspect or bystander events, and state charges aren't brought, no matter how meritorious that decision to not bring state charges, there's always a cry for federal civil rights charges to be brought. I don't see a basis for those here either. But of course, that's the federal government's a different jurisdiction, different decision makers, different politics involved. Well, similar, but different politics involved. And so the officers not criminally charged under state law are still at risk of federal civil rights charges. So that's why he's taking the Fifth and not testifying in this trial. In fact, I'm surprised he would give a YouTube interview given those circumstances, but presumably he did that in consultation with counsel. Okay, so that was the criminal statute. Now let's start looking at the possible defenses here. The primary self-defense statute under Kentucky law is this one, and I'll zoom it up again. This is statute 503050. And again, for all of these, you can just point your browser to lawofselfdefense.com/ in this case, 503050 without the dot. It'll pull up the statute for you. This is the core self-defense statute, use of physical force in self-protection. Now, many states, when they write their self-defense statute, it includes the one statute covers both defending yourself and defending others. They just include the third person pronoun in the self-defense statute. So it would say to the effect of you're privileged to use force in defense of yourself or others if, and then it would set out the conditions for self-defense, those five elements of self-defense. Excuse me. So what Kentucky does is it's one of the states that actually separates to do. So it has a self-defense statute and then it has a separate defense of other statute. Really, it's the same conditions for each. Although, of course, the dynamics of coming to the defense of another person are slightly different than defending yourself. So we'll see that when we look at the defense of other statute. But here we have the Kentucky self-defense statute. Very, very straightforward, with the possible exception of the third paragraph, which isn't unusual, but it's often in a statute by itself. And here Kentucky puts it in the self-defense statute itself. Basically, first, the statute sets out the conditions for the use of any degree of physical force, even just non-deadly physical force. The conditions that must be met before you can use even merely non-deadly force in self-defense. And essentially, it's when it's necessary to protect yourself against the use or imminent use of unlawful physical force by another person. So it sets out the conditions, the check boxes that have to be hit for using any degree of force, no matter how modest, and justifying it as self-defense. Then in the next paragraph, if you want to use deadly force in self-defense, it sets out a bunch of additional conditions. So the use of deadly physical force by a defendant upon another is justifiable under Section 1. So that incorporates the first paragraph we just read, only when the defendant believes that such force is necessary to protect himself against death, serious physical injury, kidnapping, sexual intercourse compelled by force or threat, felony involving the use of force, or under those circumstances pursuant to 503.055, which is a defense of highly defensible property statute, your home defense statute, basically. So it's saying before you can use deadly force in self-defense, you have to be facing a deadly force threat, which the law defines as death, serious bodily injury, or some enumerated list of forcible felonies, which is what we have here, or defense of dwelling and the whatever extra conditions might be required for defense of dwelling as set out in this other statute referenced here, which we'll talk about in a moment. So that's the first paragraph is the any degree of force in self-defense statute. The second paragraph is the additional requirements for using deadly defensive force in self-defense. The third is a little unusual to find actually in a core self-defense statute, but basically it's a battered spouse syndrome provision. So normally, if you kill somebody, their character cannot be brought into the trial, absent some unusual conditions. So the fact that they may have been a bad person is not something the jury will hear, unless, and to my knowledge, every state now has a provision for this, unless your killing of that other person was a consequence of some kind of long-standing domestic abuse that was occurring. Then that dead person's character may be able to be brought in so that the jury can hear it. And this is a battered spouse syndrome. It's really a rule of evidence. It's allowing in character evidence that would not normally be permitted under the circumstances of a killing committed in the context of long-standing domestic abuse. And typically the consequence, if this evidence is admitted and the jury buys it and wants to mitigate, in effect, the conviction of the defendant, instead of it being murder for having killed that other person, it can be mitigated down to the equivalent of manslaughter, which sounds horrible. Manslaughter is not a great conviction. But manslaughter, you might be sentenced to 10 years and serve a third of that and get out, 3-4 years in prison, get out on probation. Murder is typically life in prison, 20 years, maybe life without possibility of early release. So manslaughter sucks unless the only alternative was a murder conviction. And then we have Kentucky's stand your ground provision, which simply says a person does not have a duty to retreat prior to the use of deadly physical force. So no duty to retreat in otherwise lawful self-defense. I mean, if your use of force doesn't meet the conditions for self-defense, this provision doesn't apply either. But if you're acting using defensive force in otherwise lawful self-defense, you don't have a legal duty to retreat. Now, one interesting facet of this Kentucky stand your ground provision is it's not conditioned on anything except that your use of force was otherwise lawful self-defense. If you look at Florida's stand your ground statute, for example, it says you don't have a duty to stand your ground if you're not engaged in unlawful activity and are otherwise in a place you have a right to be. Kentucky doesn't add those conditions before you qualify for self-defense. If you qualify for stand your ground, if your conduct is otherwise lawful self-defense, you don't have a duty to retreat, period. And part of this is that Kentucky is actually one of the oldest stand your ground states. In fact, they used to call them true man laws back in the 1800s. So it's been the law there forever. It's very, very old common law there, and most of the time, common law stand your ground provisions didn't have any conditions, and so when it was codified in Kentucky statute, it also didn't carry any conditions with it. When you see stand your ground adopted as a matter of legislature in modern times, well, that involved debate and compromise, and that's where you see those kinds of the Florida kinds of conditions incorporated into stand your ground. So this is the standard self-defense statute. So he clearly used, the defendant here used deadly force upon another, well, towards another. So it's justifiable to do that if he believes such force is necessary to protect himself against death, serious physical injury. Well, let's just say death. There was incoming gunfire. So that's all we really know. But justified inherently requires that the use of the force was reasonable. And reasonable means non-reckless. What would have been otherwise lawful self-defense, if you just cover up your eyes and you do a magazine dump down the street, even though you were trying to hit the guy with the machete who was charging you and really intended to kill you, a reckless use of force is not going to be justified, especially to the extent that it presents a danger or causes harm to non-attackers. By the way, those of you on YouTube, we're getting awfully close to 30,000 subscribers. If you could do me the kindness of hitting that subscribe button, which you have to do, I think. Oh, you know what? I just realized that I forgot to set some very important, silly me. That would cause me trouble. Excuse me. All right. Being a boomer, I muted myself and forgot to take it off. So we're, I don't know how to share how many subscribers we have. I don't even know if that's a setting. I'll tell you, it's 29,000 something, the low 29,000s. It would be great to get to 30,000 and, of course, keep going from there. But we're awfully close to 30,000 in particular. And you do need to be a subscriber to comment. That wasn't on when I started today's stream. I forgot to set it. Another boomer moment. It is set now. So please, if you could smash that subscribe button, help us get to 30,000. That would be greatly appreciated. So back to the self-defense statute. For the use of the force to be justified, it's inherently required that it be reasonable force. Reasonableness is one of the required elements of any claim of self-defense. And it's not reasonable if it's wanton, if it's reckless, if it's negligent. So one way to attack a claim of self-defense is that it was not justified because it was not reasonable, because it was wanton. So the question is, again, we come back to this. The core legal question here is going to be, was the manner of this defendant firing those 10 shots from his AR, was it wanton in the sense that apparently he did not have discrete targets he was actually engaging, but something more akin to muzzle flashes. Now, we're going to hear in his own words. We're going to hear his interview at the police station shortly, and we're going to hear the opening statement of his attorney. So that'll be the key question here. Under the totality of the circumstances, the incoming fire, one of his colleagues already shot in the femoral artery, rounds inbound, both of his colleagues returning fire at the same rate or more than he was the manner of his use of defensive force in those circumstances so unreasonable as to negate his claim of justification under this self-protection law. But of course, it's not only self-protection that could provide a justification, because we also have protection of another in addition to self-defense. So let's look at the protection of another statute here. And this is not too hard to read. 503070, protection of another. Now, again, many states combine defense of self and defense of others in the same statute. Kentucky chooses to address them differently, but the overall structure is essentially the same. In the self-defense statute, the first paragraph was the conditions that have to be met before any force, even mere non-deadly force, could be used in self-defense. That's true here. The use of physical force, doesn't say deadly force, just says physical force, is justifiable when necessary to protect a third person against the use or imminent use of unlawful force by another. And because this is a defense of others, we have to account for the fact that it's not you're defending. So they include here, under the circumstances as the defendant believes them to be, the person whom he seeks to protect would himself have been justified in using such protection. So it's what I refer to as a reasonable perception, defense of others' jurisdiction. You have to have a reasonable perception that the person you're defending would themselves have been privileged to act in self-defense. You might be wrong about that. Maybe they were, you turn a corner, you see two people fighting, you don't know how that fight started. Maybe the person you're defending was the initial aggressor in that fight and therefore would not have a privilege of self-defense themselves. You can still be okay coming to the defense so long as your perception of them being privileged to use self-defense would be a reasonable perception. Now, I would caution, there are states out there that essentially say, well, if you turn a corner and see a fight in progress, you can't have a reasonable perception because you can't know how that fight started. So like Virginia, for example, basically says, hey, if you come to the defense of another person, we'll allow you to rely on your reasonable perception of events if you saw the start of the fight. But if you didn't see the start of the fight and you come to the defense of the wrong person, that's on you. That's not legally justified. So you do have to be careful about these defense of other scenarios and legal provisions, because when you're defending yourself, at least or think what's actually happening. When you're coming to the defense of a stranger, it's a lot more complicated. There's a lot more ambiguity risk in coming to the defense of a stranger in many cases than in defending yourself. But other than that special provision here for taking into account that you're defending a third person rather than yourself, it's basically the same language as using non-deadly force in self-defense. And then the second paragraph of the statute is using deadly force in self-defense, and it adds in additional conditions for the use of deadly force. Same kind of thing. You have to be defending that other person against death, serious physical injury, kidnapping, sexual intercourse compelled by force or threat, or other felony involving the use of force, or defense of highly defensible property. So same basic structure. Again, that language to account for the fact that you're defending another person rather than yourself. And here we have a stand your ground provision. And notice that Kentucky stand your ground in the context of defense of another person is different than in the context of defense of yourself. In defense of yourself, it simply said you don't have a duty to retreat. In defense of others, it says you don't have a duty to retreat if you're in a place where you have a right to be. So that's one of the conditions I just talked about Florida having in its stand your ground provision. And here Kentucky has it in theirs, in the context of defense of others. Let's see. Next, we have, so of course, the defendant here would be arguing this as well, that he was using force, firing those 10 rounds from his AR, not just in defense of himself under the previous statute, but also in defense of his fellow officers under this statute 503070. But wait, there's more. We also have a special provision just for cops. Use of physical force in law enforcement. So these are, they mostly parallel the provisions for using force in self-defense by anybody, but they include reference to things like use of force in making an arrest. And the overall structure is the same as use of force in defense of yourself or others for the general public. The first paragraph sets out the conditions for the use of force, any degree of force, for law enforcement. It includes things like acting under official authority, making or assisting in an arrest, and a bunch of subconditions under that. That's all the first paragraph, any force by the officer. And then there are additional conditions for the use of deadly force as a law enforcement officer. Now, these don't replace self-defense. That officer still has every privilege of self-defense that a non-officer would have. These are additional protective or justification provisions that apply to law enforcement officers in the course of their duty above and beyond the privilege of self-defense that would not apply to people who are not law enforcement officers. So the use of deadly physical force upon a defender, by a defendant upon another is justifiable only when the defendant in effecting the arrest is authorized to act as a police officer. So it would not apply in a citizen's arrest case. There's no state in the country where you're allowed to use deadly force in effecting a citizen's arrest. Also, and the arrest is for a felony involving the use or threatened use of physical force likely to cause death or serious bodily injury, and the defendant believes the person to be arrested is likely to endanger human life unless apprehended without delay. Arguably, all this would apply to the shooting here. They were being shot at by Kenneth Walker. Kenneth Walker's warrants were for pending charges that gave rise to this warrant were for drug dealing and gun charges. The gun charges are almost certainly violence related. In many jurisdictions, drug dealing is considered an inherently violent activity because of the propensity to foment violence in the course of dealing contraband. In any case, shots were incoming, so certainly shooting at the police would be at least probable cause to believe it's unlawful. And the fact that the shooting was not just imminent, but actually occurring would give rise to a reasonable belief that the person to be arrested is likely to endanger human life unless apprehended without delay. Frankly, we don't really need these provisions, these special justifications for use of force for a cop, because assuming the shots were justified and reasonable, self-defense and defense of others would clearly apply. And if the shots were not justified and reasonable, this wouldn't apply either. So it doesn't really add much to the equation, but he is a police officer, was executing a warrant, making an arrest. So I mentioned it. So in the interest of completion. So separately, I had mentioned earlier that Kentucky is one of the states that has a self-defense immunity provision. So let's take a look at that. And here it is, Statute 503-085. Basically, it says a person who uses force as permitted in self-defense, defense of highly defensible property, defense of others, or defense of property is justified in using such force and is immune from criminal prosecution and civil action for the use of force. Unless the force used was against a police officer acting in performance of his or her duties. So Kenneth Walker's firing of shots at the police, even if he had a reasonable perception that, or a reasonable mistaken belief that it was a home invasion, didn't realize there were cops, well, they were cops. So he wouldn't qualify for self-defense immunity for that use of force. Again, we saw this in Florida too. A law enforcement agency may use standard procedures for investigating, but they're not supposed to even arrest the person for using force unless it determines there's probable cause that the force used was unlawful. So what this statutory provision is supposed to be doing is compelling the cops to do something they don't normally do. So normally when they come upon a use of force event and the party who used force is claiming self-defense, the cops don't concern themselves with the self-defense side of the coin. They only look at the use of force side of the coin. And if there is an apparent use of force, probable cause to believe that person used force against the victim, there's probable cause to make an arrest there. And if self-defense is going to be argued, it's going to be argued down the road by other people, not the cop's problem. He makes the arrest and he lets self-defense work its way through the system at some later date, not involving him. This statutory provision is supposed to compel the officers on the scene to make the self-defense assessment there. So determine not just whether there's probable cause that the use of force occurred, which in a legitimate self-defense case always exists, right? Because self-defense is a defense of confession and avoidance. You're not saying I didn't do it. You're saying I did it. It was me, but I did it with the justification of self-defense. So this statute is supposed to compel or oblige the officers on the scene to not just evaluate probable cause for the use of force itself, but also probable cause for whether or not it was self-defense, and then not make an arrest if it appears there's probable cause it was self-defense, so that the person who acted in legitimate self-defense isn't even subject to arrest. Is this executed by responding officers to the spirit of the law? Not often, unfortunately. It ought to be, but it just, in practice, it's as often unobserved as it is observed. And then what else? Oh, here's that other provision that could theoretically apply here in the case of this defendant officer. The court shall award reasonable attorney's fees, court costs, compensation for loss of income, and all expenses incurred by the defendant in defending any civil action brought by a plaintiff if the court finds the defendant is immune from prosecution under this section. So this may be why the Breonna Taylor family has not sued the officer yet in civil court, because they run the risk that they could sue in civil court. He'll demand an immunity hearing. The immunity hearing will go his way. He'll be granted immunity, and then they'll be on the hook for all this stuff associated with the civil case: the court costs, compensation for lost income, attorney's fees, all that stuff. Why take that risk when you know the guy's going to criminal trial? Because if he's found guilty at criminal trial and has raised the legal defense of self-defense or defense of others, because the jury found him guilty, obviously they must have concluded necessarily that those defenses had been disproven beyond a reasonable doubt, which is a much higher level of disproof than required in a civil suit. So he's cooked for the civil suit if he's convicted in this trial. So they may be, and certainly he won't get a grant of immunity if he's convicted to have been unjustified beyond a reasonable doubt. He won't qualify for immunity. So if he's convicted, they don't have to worry about this provision. They'll bring their lawsuit. They'll win as a matter of course, and they don't run this risk. So that may be possibly, I would expect, the reason they haven't already sued him civilly. They're waiting for the outcome of this trial. Then we also have a couple of other statutes. This one I'll just hit quickly. Let's see. It's a defense of property provision. This is simply the defense of, the first paragraph is really defense of property, personal property, or real property, but it's not being invaded. It's only subject to some kind of simple trespass, like somebody in your front yard after you've told them to go away. You can use physical force to prevent, and some of these are really personal violent crimes. They're forcible felonies against a person crime. They're not really property crimes. But this provision says you can use physical force. And again, this means any degree of physical force, really non-deadly physical force is what they mean, to prevent the commission of criminal trespass, robbery, burglary, or other felony involving the use of force. Of course, we already saw you can use deadly defensive force against any felony involving the use of force. And really, robbery is a threat of force against person. So if it's a deadly threat of force, that's simply a self-defense case, straight up allowed for the deadly use of deadly defensive force. Burglary is normally unlawful entry into a dwelling for the purpose of committing another crime. That really tends to be an unlawful home intruder, so falls under defense of highly defensible property, where deadly defensive force would be presumed to be lawful, as we'll see in a moment. Criminal trespass, normally only non-deadly force. They don't want you to use deadly force to remove a simple trespasser in the absence of threat of violence against other persons. Then, just like we saw with the self-defense statute and defense of other statute, where this first paragraph is the use of non-deadly force, the conditions that have to be met for that, the second paragraph adds additional conditions for the use of deadly force in defense of property. So now we have someone who's trying to dispossess you of your dwelling. They're throwing you out of your castle. To prevent that, you can use deadly defensive force under Kentucky law. They're committing a burglary, robbery, or other felony involving force. These were also included under non-deadly force in defense of property, but you see here they're also included under deadly force in defense of property. But remember, these are really all felonies that involve an implicit threat of force against a person, not just against property. They're not just, picking up your backpack and running off with it. Or the committing or attempting to commit arson of a dwelling or building in your possession. So not necessarily your neighbor's dwelling or business or building, but arson is traditionally considered a forcible felony that carries an imminent threat of death or serious bodily harm to innocent persons because, of course, of the nature of a building being set on fire, extremely hazardous, extremely easy for people to be trapped, overcome by smoke, and so forth. It's a deadly force attack, in effect. And again, we have the stand your ground provision with that condition that we also saw with regard to defense of others, but not regard to self-defense. A person does not have a duty to retreat if the person is in a place where he or she has a right to be. Now, for this case, of course, this defendant in this trial is not claiming to have used force in defense of property, so it wouldn't really apply in most any context. It could arguably apply to Kenneth Walker, the boyfriend who claims he didn't know it was police coming in to the apartment, that he thought it was some kind of home intrusion, some kind of burglary. So he might have attempted. Now, I believe all the charges against him were dismissed largely for, I expect, political reasons. But had he been charged and brought to trial, those are certainly defenses I would have raised on his behalf. And then we have this next statute, use of defensive force regarding dwelling, residence, or occupied vehicle. Again, these are all forms of highly defensible property. So this is what I call a highly defensible property statute. It's different than defense of simple property. It's different than defense of property, your backpack that someone grabs and tries to run off with. This is a particular character of property, highly defensible property. Different states define that to different degrees of scope. All states include at least your home as highly defensible property, your castle. Many states also include a place of business. Sometimes it has to be your business. Sometimes it can be any place of business. And many states also include an occupied motor vehicle. Now, an empty motor vehicle is simply personal property, but an occupied motor vehicle can qualify in many states as highly defensible property, just like your home, just like your castle. And the reason these properties are treated differently, at least when they're occupied, is what's being protected here is not really the physical structure of the home or the physical structure of the building or the physical integrity of the car. These properties are serving as surrogates for the people inside them because their primary purpose is the shelter and protection of people. So the thinking is anyone who breaches these particular types of property with people inside is really trying to get to the people. So we'll enact a separate set of rules for the use of force in the context of these very specifically defined, highly defensible properties that would not apply these special provisions outside the context of highly defensible property. And the most common of these is that these special provisions will create a legal presumption that the defender had a reasonable fear of imminent death or great bodily harm when using defensive force intended or likely to cause death or great bodily harm. So if you're using deadly force in defense of highly defensible property, the law assumes that you have a reasonable fear of imminent death at the hands of that intruder. Now, think about what that's giving you. That's giving you 3 of the 5 elements of self-defense. And folks, if you don't know, the 5 elements of self-defense are innocence, imminence, proportionality, avoidance, and reasonableness. We give away this infographic for free. You can get it at lawofselfdefense.com/elements. It's just a PDF download. If you don't know these 5 elements, you can't possibly understand use of force law. These are the building blocks of every use of force justification law in each of the 50 states. So if you don't understand these 5 elements, at the very least, please download this infographic, lawofselfdefense.com/elements. But what this legal presumption is doing is giving you 3 of 5 of those. It's giving you reasonableness, imminence, and proportionality. The presumption that you were facing a deadly force threat, not merely a non-deadly force threat. And the fact that you're in your home, the Castle Doctrine already says you're relieved of any otherwise existing duty to retreat, which you wouldn't have in Kentucky anyway, because it's a stand your ground state. So that takes care of the element of avoidance. That's 4 of the 5 elements that you need to justify your use of deadly defensive force. They're giving that to you under this legal presumption if you meet the conditions for this legal presumption. The only element not given to you is the element of innocence, that you were not the initial aggressor in the fight. But if an intruder is unlawfully and forcibly entering your home, innocence is kind of baked into the cake. So defense of home in the context of these statutes is pretty hard to screw up. Now, people do screw it up, but it's hard to do. So what are the conditions that have to be met for you to qualify for this unbelievably great legal presumption? Well, the person you're defending against has to be unlawfully and forcibly entering the highly defensible property, whether that's your dwelling, residence, or occupied vehicle, or they have to be attempting to forcibly remove someone, so kind of a kidnapping scenario from that property. And the person acting in defense knew or had reason to know that there was this forcible and unlawful entry or this unlawful taking from the property. Meet those conditions, you qualify for this legal presumption in the context of highly defensible property. Unless you trigger one of the exceptions. And the exceptions include things like, well, first of all, it's necessary that the person who you're calling an intruder, that it wasn't also their castle, that they're not a co-dweller, for example, don't have a legal privilege to be there. It also must be that if you're claiming you did this in a kidnapping scenario, that the person doing the quote unquote kidnapping didn't have legal custody of the person they're taking. If they had legal custody, it was not a kidnapping scenario. Also, if you're using the property for unlawful activity, if you're dealing drugs out of the property, you don't get the benefit of this legal presumption. Or if the person you use force against is a law enforcement officer who's entering, you don't get the benefit of this presumption. Now, if you don't get the benefit of the presumption, that doesn't mean you don't have the privilege of self-defense. You can still argue self-defense, but you're back to having to prove, or at least support, each of the 5 elements of a claim of self-defense. You don't get the benefit of the legal presumption of those elements being established. At least that's what this statute would suggest is the case. It's a little more complicated than that, but that's the general idea. So this would not apply to the officers. They were clearly not engaged in the protection of highly defensible property. But again, it could apply to Kenneth Walker, the boyfriend, who might argue that, hey, I thought it was a home invasion. I thought these were forcible and unlawful intruders. So I should get the benefit of this statute, the presumption that I had a reasonable belief that they were an imminent threat of death or serious bodily injury to me and others in the dwelling. Now, it might be a hard argument if he had drugs in the apartment, but and of course, the reason for the arrest was largely because there was probable cause to believe he was a drug dealer. But I believe when they searched the apartment after this event, they didn't find drugs or guns in it. So that wouldn't be a triggered exclusion. On the other hand, of course, the people he used force against were law enforcement officers in the conduct of their duty. And so almost certainly that would trigger the exclusion, lose him this legal presumption. Let's see. Oh, it looks like this other video. I have to do a little bit more processing here. Give me just a moment to get that started. I'm hoping to get that ready for all of you. So those are all the statutory provisions we need to talk about. Again, the core legal defense here, I expect, is going to be defense of self, defense of others, maybe use of force as a law enforcement officer. We'll see when we hear the defense opening statement, which I ought to be able to pull up right here. So now I'd like to share with you the opening statement of the state. This is about 40 minutes long. I imagine I'll pause it from time to time if something interesting is said, but otherwise I'll just let it more or less roll through and see if we can't get through it and understand the state's narrative of guilt in this case, why they believe this defendant should be found guilty of 3 counts of wanton endangerment for firing 10 rounds from his AR rifle into Breonna Taylor's apartment. Now, I do want to make clear, I had gotten the impression myself from media reports that this guy had kind of fired shots randomly into some other apartment, which would certainly suggest some degree of recklessness. In fact, what he was doing was firing into Breonna Taylor's apartment, but the AR rounds continued on into someone else's apartment. So it's not that he wasn't directing his fire in the right direction at all, or in an entirely imaginary or speculative direction. He was at least directing his fire in the general direction of the apparent threat, but maybe he didn't have enough of a target to justify discharging those rounds. And the fact that they then entered another apartment obviously creates a danger to others. Now, there is a legal doctrine here we should understand called the doctrine of transferred intent. And transferred intent is normally a doctrine that's applied in the negative context. So if I decide I want to murder you, I have murderous intent towards you, and I fire a shot at your head, which if it struck you and killed you would be murder. I had the intent to murder you, but my shot misses you, and it travels on to strike Sister Mary in the head and kills her. Now, I never intended to hurt Sister Mary. I didn't even know she was down the street. I never saw her. But the law says that my murderous intent towards you transfers to her. So I can be convicted of intentionally murdering her, even though I didn't actually have the intent to murder her. The intent I had to murder you, it's said to have transferred over. Well, transferred intent also works in the positive sense. If I fire a shot at you, not because I'm trying to murder you, but because you're coming at me with a machete, trying to murder me, and I'm acting in lawful self-defense, so that I have a good intent for firing my shot at you, and my shot misses and hits and kills Sister Mary down the street, I ought not have criminal liability for that, because my good intent in firing at you transfers over to Sister Mary. My shooting of her also is said to have had that, unfortunate, tragic outcome, but without criminal intent. So I'm sure that's what the defense will argue here in part, that the shooting at Kenneth Walker was justified, had good intent, and therefore whatever harm would have resulted, the good intent would have carried with that. It would have been an unfortunate but not criminal killing of a bystander if a killing had happened. In this case, the endangerment of a bystander. In which case, if it was justified, it's not wanton. It's not reckless. There ought not be criminal liability on these wanton endangerment charges. The difficulty there is that for the good transferred intent to be valid, the use of force has to be non-reckless. It has to be reasonable. So if the guy with the machete is coming at you again, he's going to kill you. And if you shoot at him deliberately, appropriately, and a shot misses or overpenetrates or whatever, the good intent would be said to have transferred to any innocent bystander struck by that round. But if you cover your eyes and do a mag dump down the street just hoping you'll hit him, and a round hits an innocent bystander and kills them, well, arguably that reckless discharge of the weapon negates the good intent. And therefore, you would be responsible for the reckless homicide of that person down the street. And of course, that's the question here. The core question is whether or not this officer's discharge of those 10 shots was reasonable under the totality of the circumstances, in which case it's justified and the endangerment to others is justified, or it's reckless, in which case there was no good intent to transfer and the endangerment is indeed wanton, reckless under Kentucky law. Okay, so that's where we are in terms of the criminal charge and the likely defenses from a statutory perspective. Let me go back and take a quick look at the comments here. So from the Law Self-Defense website, our members there ask, Miles Dog asked, did the LEO being charged have eyes on the specific threat, or was he firing through concealment or a wall? Well, we're going to find out. We're going to hear his claims, at least, as well as the allegations of the state and the defense in their opening statements. My understanding is not that he was firing blindly through a wall or through a door, but that he may have been firing at muzzle flashes without a distinct target. So it's not quite the same, right, as just firing blindly through a wall. You know there's an apparent threat there because you can see the muzzle flashes, but maybe you don't have enough of a discrete target to have any particular degree of confidence you're actually going to hit something. I mean, I've never been in combat, but I have plenty of friends who have been, and they've told it's shooting at muzzle flashes is pretty much for suppressive purposes, but the prospects of the intended target are essentially zero. In which case, especially in a civilian setting, an urban setting, apartment building setting, there's other apartments around, there's other people around, maybe that is reckless. And frankly, I'm ambivalent on that issue. I can see it going either way. I see at best a coin toss here. And it would not surprise me at all for a reasonable jury to find reckless, wanton conduct here. In that case, reckless endangerment would be the appropriate criminal offense, and a verdict of guilty would be appropriate. But I'm willing to listen to the defense side before I come to that conclusion, because otherwise we're just responding to rumors and media reports and propaganda, which are really all just the same things, right? What about the super chats? Let's see what we got. It looks like we may be all caught up there. One more, all work, no play, says, thank you for your time to explain this case. Hope your wife is doing well. Yes, my wife is doing amazingly well. For those who don't know, she was diagnosed with cancer late last year, breast cancer. She had surgery for that. The surgery went wonderfully well. She was looking at a possible series of surgeries. In fact, she only had to have the one, and she's recovering beautifully. I'd say she's about 95% of the way back. And we're looking forward to a celebratory Disney trip in a couple of months to celebrate the good outcome of that. So getting cancer is never a good thing, but if it has to happen, we were about as fortunate as one could ever hope to be in that regard. So thank you for your kind thoughts. All right, so at this point, I would like to pull up the state opening statement and start playing that. I'll put it on full screen, and we can see what the state has to do about this case. Let's see. Hopefully the volume will work. So I'll pause there real quick. This is the lead prosecutor in the case. Her name is Assistant Attorney General Barbara Whaley, Whaley. The defense attorney is Stu Matthews. So just so we have names associated with the people involved, this is ADA or AAG, I guess is the phrase Kentucky prefers, Barbara Whaley. As another anecdote, so Kentucky calls itself a commonwealth. I believe there's 4 commonwealth states. My own state, home state, or where I'm a member of the bar of Massachusetts, although I now live in Colorado. It was the Commonwealth of Massachusetts, the Commonwealth of Kentucky, the Commonwealth, I believe, of Pennsylvania, and I think the 4th one is the Commonwealth of Virginia, if I recall correctly. Okay, no sound on the video I'm hearing. So let me try that again. Dear Lord. I could hear it on my headphones, so I just assumed it was going out. I wonder why it's not working. Let's see. Oops, that's why. Okay, let's try it again. So she just started. Sorry, this is Prosecutor Whaley. She just started with reading out the counts of wanton recklessness. Let me. I'll pull it back a couple seconds, and we're not that far into it. So hopefully it'll work now. This time I will pay attention. I will pay attention to the chat.
Wealth to be in this case. First, it's my responsibility to read you the indictment. wanton endangerment in the first degree, count 1. On or about March 13, 2020 in Jefferson County, Kentucky, the above named defendant, Brett Hankerson, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into an apartment occupied by C.E. initials. Count 2.
So they're
wanton
not
endangerment in
specifying the
first degree.
victims.
On or about March 13, 2020, in Jefferson County, Kentucky, the above
Well, they're
named
specifying them
defendant,
by
Brett
initials.
Hankerson, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into an apartment occupied by C.N. Count 3, wanton endangerment in the first degree. On or about March 13, 2020, in Jefferson County, Kentucky, the above named defendant, Brett Hankerson, committed the offense of wanton endangerment in the first degree when, under circumstances manifesting extreme indifference to human life, he wantonly shot a gun into an apartment occupied by Z.F., signed by the foreperson.
So interesting. None of the victims of these that are the bases for these 3 counts of wanton endangerment were Kenneth Walker or Breonna Taylor. These are all the 3 people, unnamed, identified only by initials, who were apparently in the apartment into which the rounds went after they zipped through Breonna Taylor's apartment.
Now, as you've heard, the indictment is not evidence. It's the charge. That charge is returned by the Jefferson County grand jury. The evidence will be what you hear in this courtroom from the witness chair. This is not a case to decide who is responsible for the death of Breonna Taylor. Breonna Taylor should not have died that night. The city of Louisville, in a civil matter, which I spoke about yesterday, paid millions of dollars to Breonna Taylor's family. But the money did not bring her back.
12 million.
Nothing will. This is not a case about the search warrant for Breonna Taylor's apartment, other than you will hear it was a valid search warrant signed by a judge. This is not a case about the Louisville Metro Police Department as far as whether or not there needs to be reform or more support for officers who put their lives on the line every day. This is not that case. This is a case about the actions of Brett Hankerson on the night of March 13, because it started about midnight, 2020. And about, as you heard, the circumstances under which he acted. You will hear that he shot into the apartment building at 3003 Springfield Drive.
By the way, that address is Breonna Taylor's apartment. That's where she lived. She wasn't just visiting Kenneth Walker's apartment. That was her apartment. That's also the address on the bank accounts of Kenneth Walker, purported drug dealer. That's part of the basis why the authorities had reason to believe that she was a co-conspirator in his drug dealing activities.
And you will hear that his bullets went through apartment 4 into apartment 3 and nearly hit Cody Etherton as he was walking down the hallway into the dining room of his apartment to see what was going on with the banging This case is about Cody and his partner, Chelsea, who was 7 months pregnant at the time, and their 5-year-old son, who was sleeping in the bedroom closest to the front door when the bullets ripped through the apartment and out their sliding glass door into the night. There was no search warrant for Cody and Chelsea's apartment. Exhibit 73A, or 73.
So they somewhat named the victims then. I guess not in the indictment, but here in the trial. Maybe they're going to call them to testify anyway.
That you will hear witnesses testify about. An apartment 4. Apartment 3.
Now, I presume the defendant, Hankerson, is going to say himself that he didn't see clear bodies as targets, because if he had
3,
and was shooting at
which you'll see in a minute, the door
well-defined, distinct bodies and just missed 10 times, that would
at the rear of the building,
arguably excusable.
And this is apartment 3's patio, through which one of the bullets shot by Brett Hankerson through this patio all the way through and exited the patio doors here and into the night. You will hear from some of the officers who were there that night to serve the search warrant. You will hear that as they approached the apartment 4, which was the apartment of Breonna Taylor, they had the warrant, which was signed as a no-knock warrant, Exhibit 5.
Hey, Nate, I think I sent you the link to join in if you want.
This is what you will hear referred to as the breezeway, the entrance.
I'll send it to you directly on Twitter DM.
In this alcove or breezeway, there are doors to 4 apartments. This is apartment 4 that you will hear a lot of testimony about. This is the entrance into the apartment of Ms. Taylor. This is apartment 3. This is Cody and Chelsea's apartment. I can't find it. Let's see. This door right here. This is apartment 2, and over out of the photo, which is directly across from apartment 4.
I put it in law tube, Nate. I don't know. I can't seem to.
Upstairs are 4 more apartments in the same design as the first floor. So 1, 2, 3, 4, 5, 6, 7, and 8 directly above 4. You will hear detectives who were assigned to execute the search warrant that it was, even though signed as a no-knock warrant, decided that it would be served.
All right, Nate, just sent you the link to join in if you want.
Knock and announce, and you'll see a photo.
DM on Twitter.
That shows a large whiteboard that was displayed at the briefing earlier that day for detectives who would be serving the warrant. And on the whiteboard, you'll see the words.
I know Nate's been following this trial very closely. I have not. So any contribution Nate would care to make would be greatly appreciated.
Springfield Drive, apartment 4. You will hear the subject of the search warrant was Breonna Taylor, who was connected to an individual named Jamarcus Glover, designated as a drug trafficking suspect. You will hear that all of the detectives who were assigned to serve the search warrant were experienced detectives, including the defendant, Brett Hankison, with approximately 20 years in law enforcement.
Close to retirement.
After the briefing, you will hear, which was earlier in the day of March 12th, those assigned to execute this search warrant met at a church nearby.
This is a
Springfield
recording
Drive
from the other
called
day.
St.
This is not the
Anthony's
trial
Church.
live.
Met in the
This is a
parking lot
recording of the
there
opening
to
statements. I was on the
discuss
Curtis Reeves trial
what
when they
the
were making
approach would
opening in
be,
this trial. So
on Springfield Drive.
can't watch two trials at the same time.
Sergeant John Mattingly was designated to be the person, the detective at the door, along with
And he got a
Detective Mike
round through the
Nobles,
femoral artery for the
who was carrying a ram.
privilege.
You'll see a photograph of a ram that was ultimately used to breach the door.
Hey, Nate.
Hey, what's going on?
Just had some free time. I haven't
Other
been able to follow this
detectives,
trial because I was on Curtis Reeves,
Miles
but I thought I'd catch up
Cosgrove,
this afternoon. So I'm a blank
Mike
slate.
Campbell,
I don't really know anything. I haven't heard any evidence, I should
Tony
say.
James.
So let me not give you any opinions because
Sean
I've been following
Hoover.
this case for a while. So I'd rather you just do your thing with the thing. I'll
Detective
chime in with stuff,
Hankison
but
Okay.
I'd rather
was
you
a
get it fresh.
canine
You know what I'm saying?
officer.
Based on what their arguments.
Meaning
Sure.
he had a dog that was trained to sniff for narcotics, a specifically trained narcotics dog.
Dog. DAWG.
That dog did not leave the vehicle of the defendant at any time. The protocol is the dog stays in the car until the warrant, till entry is made.
Don't want the dog getting shot.
Search is in progress. If the dog is needed, then the dog would be retrieved from the vehicle. That did not happen here. The dog never left the car.
I'm not sure how important that is.
Yeah, because I know there's different types of dogs. You got search dogs, and then you have combat dogs. So
It was
It might have been a
approximately
search dog.
11:45. Exhibit 14.
Didn't she play Michael's wife in the Godfather movies?
Let's go to 19. This is another photo of the breezeway, and now you can see apartment 1. You can see the size of the area here.
Well, just so they're
not
probably not going to mention it, but obviously there was they thought this was
Exhibit 19.
the what's it called, the stash house for the drug trade,
Right.
because they were getting
This photo
packages. So
taken
that's
further
why they
back.
were there. They were there legitimately.
That's the stairs going up to the other 4 apartments on the second floor, this being 8, 7, 6, and then 5 over here. The sliding glass doors of apartment 4 and this the stairs, you cannot see the door to apartment 4, but it's right here. This is the sliding glass doors, and you can see the railing going around the little patio. This photo was taken the morning after, so it's daylight. But obviously, when this event occurred, it was pitch dark at midnight.
I like the black box.
You
You
see
black boxed them, huh?
Shattering of the window, the glass door in these patio doors. Those are the shots that the defendant made through these doors that went all the way through into the other apartment 3 here, which mirrors apartment 4. There's a common wall between the two of them. This diagram over to your right is a floor plan of apartment 3. The front door being here, dining, kitchen, bedroom.
This is a terrible opening.
And here
Yes.
is the
Yes.
patio. that
All these
leads out into
really
the back
irrelevant details.
of the
You're supposed to be telling a story arc here.
So the bullets you will hear came
All this detail comes out during the
from
trial.
apartment 4, which would be down here. This is the common wall. Came through the sliding door here, through the dining room wall, all the way through out the patio door.
I'm already asleep.
There were 3 bullets.
Yeah, but we're not hostage jurors, so
There were
unfortunately.
5 bullets
It's like they start falling asleep, they
shot
get yelled at.
by the defendant through the patio doors. There were 5. 3 made it through all the way into apartment 3. 1 out the patio doors of apartment 3. A 4th one stuck in the stud of this wall, of this common wall. And a 5th one that went through these doors didn't make it past the floor of this, apartment 3. Didn't make it through the apartment
She's had
4.
2 years to prepare this opening statement.
Very damaged bullet. It was later determined to
Do
have
better,
been
folks.
fired by Detective Hankison's gun. It was found on the floor in the dining room of apartment 4, which would be right here. They mirrored
She's been
each
doing
other.
this a long time.
So it didn't make it
I would sure
through
looks
the
like
wall,
it.
but nevertheless was shot through.
See, but you know her conviction
sliding glass
is like
door. So
99%
there
or
were
something like that. It's probably super high.
Yeah.
And she
5
gives all of her stuff
total
like this.
bullets
It's just, no
shot
reason
by
to
the
improve.
defendant through
That's
this
probably
door.
100% correct.
Now, as
It's a little
the
different
group
on the
of
defense side
detectives
where you
approached
can lose 99% of the time.
breezeway to execute the search warrant and had lined up in a formation with Detective Mattingly and Detective Nobles, who's the detective with the ram, at the front door. You will hear that Detective James was over by this wall.
That's the guy to be, the guy with the ram.
Detective
Just knock the door down, step out of the way.
And when the
Further
shots
back.
come, you had nothing to worry about.
Detective Campbell was the farthest back. Lieutenant Hoover also back in this area, as was the defendant.
This is not a killing case,
Detective
folks, because it has
Hankison.
nothing to do with the death of Breonna Taylor. This
Because
is
there's
just
not
wanton
room
endangerment.
in that little alcove for 7 men to stand all bunched up. So
This is like if Kim Potter knew she had the
Mattingly
gun.
and Cosgrove,
Right,
Mattingly
yep.
and Nobles, basically at the door. Now, once they were in position, you will hear that a gentleman came out this door, which is apartment 8, came out the door to the railing or to the top of the stairs, and you will hear from him. His name's Aaron Sarpy, who was there to pick up his daughter from the babysitter. And he was preparing, he had come up to this apartment prior to the detective's arrival. He had already come to pick up his daughter. And actually his white Sequoia was parked out in the parking lot behind. It was in a
Now,
perpendicular.
Can you pause it real quick for a second?
He had
Yeah.
pulled up and just parked it there. He didn't.
Now, this is where one of the biggest media lies about this case comes from this particular point she's trying to make. So whenever you do investigations, especially in the criminal nature, there's an element of where people were at to hear things. So like say the people who are inside, generally if you're inside with the TV on, you can't hear what's going on outside. So the news media was reporting that no one in this apartment complex heard the police scream police when they were at the door. But the guy she's talking about now happened to be outside on that balcony when police were outside. And he said, hey, I heard them say, police. And then they told me to get inside.
Yeah.
But the news media said, well, listen, that's just one person. not telling people that that one person was literally right there hearing the police say it, and said, well, no one else heard it, and those people were in the shower, watching a movie and so forth and so forth. So that's why you'll hear a lot of people when they're talking about this case said that the police never announced themselves. That's not true, because the one person that can hear it did say they announced themselves.
No, I don't think they had to. I think it was a no-knock warrant.
It was a no-knock.
They had the option not to announce, but of course, there's a lot of politics around no-knocks. I mean, I'm not a fan of no-knocks myself, so the fact that they chose not to do a no-knock, and it doesn't matter. Everybody in the world doesn't have to hear the announcement. If one person heard the announcement, there was an announcement.
Yeah.
So although it was technically, and of course, this is one of the ways the media does propaganda, they lie by only giving you half the information. It's true. It was a no-knock warrant. It wasn't served in a no-knock fashion, however.
Correct.
Not that it matters, really, because, I mean, the charge here is the guy discharged his weapon recklessly.
Yeah.
So whether they announced or not doesn't change the fact of whether or not he was firing recklessly.
And before you play it, I'll even say this: if they would have served this as a no-knock warrant, she would still be alive, because he wouldn't have had time to get the gun. You bust in, you run in. They were laying in bed. Like he even said, we were groggy, we didn't hear anything, we had to slip up. But if you bust in and run up on him, he can't get the gun by actually knocking and doing what most people I think would be the right thing to do. This is kind of what caused this. So,
right. Yep.
Pull into a parking spot to run up and get his daughter. When he came out, you will hear detectives told him to go back in. Prior to him coming out, they had begun to knock on the door of apartment 4. They had begun to announce police search warrant. When this gentleman came out, Detective Hankison in particular began to engage verbally with him, telling him to get back in, and continued to engage verbally with the gentleman. The detectives who were up at the door couldn't see Mr. Sarpe. They were too far under this that landing. But Hankison was back here. He could very well see Mr. Sarpe and continue to engage with him to get back inside, get back. This escalated the situation.
All right. I bumped it to 1.25, folks. That was a good suggestion.
At that point, finally, Sarpe did
now
go
she
back
sounds
in.
almost normal.
At that point is when the knocking had been going on.
She does.
No response. A decision was made after the gentleman went back inside to go ahead and breach the door.
These presentations are so bad, people, because they don't have to improve. It's easy when you pick the cases that you know you can win.
The ram against
defense attorneys don't have that option.
Side, can't see the door here, but the door handle side is on the right of the door to apartment 4.
That's the lead counsel, the white-haired guy there.
Make the breach. Second did not, and finally third, I believe it was a third, possibly the fourth, that actually breached the door handle side at where the lock and the handle are on the right side, so that when the door opened, it went right to left. There was no knocking the door off the hinges. The door, as you saw in the earlier photograph, Exhibit 5, which was taken after the next morning. As you see, the door is perfectly still on the hinges. And you can't see, but inside the lock here, doorknob area is where it was breached. That caused it to open, staying on the hinges, opening up.
Well, it's hard to take it off at the hinges.
That,
that's a lot of work.
and this was
so true.
this happened quickly. During the time that the breach was taking place, Detective Cosgrove, who had been behind these two who were at the door, moved up to cover Detective Nobles with the ram. He moved up in this direction to cover because the defendant was too busy engaging with Mr. Sarpe upstairs. So Cosgrove moved up to cover the guy with the ram. Because the guy with the ram doesn't have any protection, but has not got his gun at the ready. So Cosgrove moved up, stepped up to cover, which put him in the line of fire. As soon as the door was breached, you will hear, as it opened up, it was pitch dark inside, and a shot came out the door immediately and hit Detective Mattingly, who was on the left side, but it was attempting to step in when he was hit in the leg.
Now, at this point in time, all the officers who are in that space, if they fire, they're all legit, right? You got fire coming at you, and you're firing to the point of when you're seeing fire coming at. So at that point, and you're going to hear that all those bullets that go toward that fire, where they've identified this is where the fire is coming from, are all legitimate. So that's why those officers weren't charged. And you're going to hear a lot of people, they should have been charged because, listen, somebody literally shot them. If they can't return fire in that scenario, the police can never return fire in any scenario. Am I right?
All right, so don't do the spoiler yet. Presumably, that would suggest that what this defendant did was different than that.
No. I'm just saying with these two cops, with this defendant, we haven't talked about this defendant because he could have seen something.
Yep. Okay.
As soon as that shot rang out and hit Detective Mattingly, he and Detective Cosgrove, who had stepped up after Detective Nobles breached the door with the ram, he spun out immediately. He spun out and was over here. So he was not in the doorway. Mattingly and Cosgrove, who had stepped up and were in the line of fire, and both returned fire after Mattingly was shot. You will hear that the defendant, Hankison, was not in the line of fire. And go back to 31A, I think.
Oh, come on.
Or 19, I guess 19. Yes. Hankison had been over here engaging with Sarpe. When the shots rang out, when the shot came from inside the apartment and hit Detective Mattingly, he ran over this direction, obviously behind this railing, and started shooting in a geometrically perpendicular to where the shot had come from inside the apartment. So those in the doorway were shooting, and this is west. This is south here. This is south. This is west, east, north. North would be this direction. So,
all right. So Nate, she's confusing me here with her directions, but let's see. Okay. I got a little. Would it be safe to say that the actual gunfire was going sideways in this image?
Yeah. Well, yeah. The people who are at the door.
Yep.
It was facing one way, and then Hankerson went.
They were facing to the right here. This door under the stairs. This door on the right is the door they breached. Gunfire was coming out from the right to the left in this image.
Correct.
And is she saying that the defendant here fired into this door that we see full frame here?
If you look over, you'll see a glass door, like on the porch.
To the right here?
Yeah, to the right, to the stairs. If you go right to the right.
Oh, so he came around that railing and was firing through the sliding glass into the apartment.
Exactly. So you got like this almost T-fire shooting. You got the fops shooting in and him shooting across like a 90-degree angle.
Okay, got it. Yep.
But he can't see into the apartment, so he's just shooting blindly in. Boy, they're shooting toward.
So there's like curtains or blinds or something, or
correct. You'll see it when she pulls it back. You'll see the curtains and blinds
from a south-north direction, where the detectives who had been in the line of fire and returned fire from the doorway after the door was breached, and and they were met with gunfire. They returned fire west-east, obviously, in the direction of where the shooter had shot from. And you will hear the shooter was at the end of the hallway. So he ran over here into actually the sidewalk. All of his casings were found in the parking lot. 10 shots were fired by the defendant. All 10 casings were found out here in the parking lot. None, of course, over here. All the casings in this breezeway that were located by the crime scene unit were casings that had been fired by the 2 detectives in the doorway, Cosgrove and Mattingly. Cody Etherton and Chelsea Napper were asleep in apartment 3 back here in this bedroom when they heard the banging, the breach, the ram. And Cody jumped up, you'll hear from him, and was walking toward the front door to see what was going on. As he got to this area, a bullet whizzed close to his head that he heard, and then saw debris, drywall, dust, where that bullet had come through. Bullets. He ran, he'll tell you, he hit the ground, crawled back to the bedroom. Chelsea Napper will testify. She woke up from sleep, and she is not, she's a very heavy sleeper, but woke up immediately from these bangings and froze.
She's got to tie it together.
Froze.
He had no target acquisition because she hasn't said that yet.
She couldn't move. She couldn't, yet knowing her 5-year-old son was asleep in this bedroom. So Cody ran back, crawled back to the bedroom.
Oh, she's horrible. She's just literally
They
reading
then
it.
were able to go get the child. As Cody came back out, the firing had stopped. The gunfire stopped. He came back out and then noticed the shattered glass of their patio door, and all the glass you'll see laying on the carpet. And you'll also hear there was a bullet, one of the bullets likely that hit above that door, the doorway, you'll see photo, and the bullet bounced back and landed, one of them landed in the carpet there. But one went all the way, did shatter the glass. They called 911. It was cold that night. So their door, which had been shattered, cold air was pouring in.
The stream should be working fine, folks.
You will hear that the radio, the defendant got on the radio.
You need to
After
update
the
your Windows
shooting,
7.
he called for patrol. You'll hear radio clips of him calling. Patrol car after patrol car came to the scene. Some of the patrol cars, you will hear, some of the patrol officers went to the back of the building. And Cody Etherton was in some danger because at that point, no one knew that he was actually in a separate apartment. So there were guns pointed at him as he stood in the shattered and put his hands out this shattered glass and saw guns pointed at him from these patrol that came. So that's part of the circumstances that were created.
This is
by the
1.25
defendant
speed,
in apartment
folks.
3. That's part of the circumstances that you will hear about.
And it even still sounds slow now.
You will hear that the defendant gave
Unless
a
I
statement.
screwed
and
it
you will hear
up.
the
Let's see.
statement.
No,
to
go to
the Public Integrity
1.5.
Unit,
It'll probably
which was
be
called to
better.
investigate the scene, to process the scene, to interview all the detectives.
That's like New
You will
York
hear
speed
that
now.
the defendant
That's normal in
claimed
my
that
ear.
He saw into the doorway,
It
front door,
is.
and he claimed that he saw a shooter in there with an AR rifle in a combat position, and that he actually was standing here that he could see him, and that he returned fire when he saw that shooter with an AR rifle start shooting.
So where I grew up, this is a
no
normal
AR rifle
conversational
in Apartment
pace,
4.
folks.
There was one pistol, a Glock 43X 9mm, which had been used by the shooter inside.
Did
And it was
you
found
get
under
those?
a bed
She put some important facts out
the
there. I don't
front
know if you
bedroom.
missed them.
Under a bed in the front bedroom, not the back bedroom, which was where Ms. Taylor and her boyfriend had been, but under a bed in the front bedroom, which window faces the parking lot. It's next to these doors. Down just a little bit.
So
One gun,
hold on, pause it.
one pistol, 9mm.
So he said that he saw someone with the AR-15, and that's who he was firing at. But if you through that window is actually another bedroom. They weren't even in there. So where they were at was in a second bedroom farther back. So he couldn't have seen anybody. But he said when he looked inside the apartment, he saw a man with an AR-15 firing, and that's impossible because that window, you wouldn't have been able to see where Breonna Taylor and her boyfriend were at. You wouldn't have been able to see them from his position at all.
Okay, and we know this because that's like where her body was found, or
that's where her body was found, and that's where the guy was. He shot back, like when he shot and he ducked. That's where everything happened.
Yeah.
So he's saying I saw somebody with an AR-15, which nobody had an AR-15. But when he looked through the window, but it's just impossible because that was the wrong bedroom. That's what she's saying now. Okay. So that's how they know. That's how they're assuming that he didn't have target acquisition.
That matched that 9mm found in the hallway, down the hallway, and there was one bullet which matched the shooter in the apartment's gun, the 9mm found under the bed. One bullet was later found out in the breezeway where Detective Mattingly had been shot. The bullet went through his leg and was found in the breezeway and was later identified as having been fired from the gun found under the bed in the apartment, the 9mm. There was never any AR long rifle. You will hear from officers who were there. You will hear from the SWAT team that came shortly after to clear the apartment. The SWAT team came to clear the apartment and you will see some body-worn cameras that the SWAT team had. You will see that the defendant, you will see him in some of these body cameras that the SWAT team were wearing, because after the shooting, the officers were assisting Mattingly to get to the hospital. He was bleeding out. But the defendant was still covering or pointing his gun at this apartment. There were patrol officers also doing that. However, once the SWAT team arrived, the other officers did not attempt to go into the apartment. The defendant did. He came to the door and attempted to go into the apartment while the SWAT team was trying to clear. You will hear from firearms examiners who tested the casings and the bullets retrieved at the scene to the gun belonging to Hankison. And as I said, they determined that all 10 of the casings found in the parking lot were fired from his. It's a Glock Model 22 40 caliber service weapon. All 10 casings in that parking lot area were fired from his gun. You will hear from firearms instructors.
Whose 10 shots were those?
Metro.
What the defendant was firing an AR, is that not right?
No. He just firing his service revolver. So no, he wasn't.
The Glock. So
the Glock. I'm sorry.
It was his Glock 22, 40 caliber rounds. Okay.
Correct. Yeah. No one had an AR.
Okay.
Takes place with officers at Louisville Metro. You will hear from an officer or a major who has knowledge of and will tell you about not only the firearms training, but the history of the training that this defendant has had in his career as a law enforcement officer. The major will describe some of the specific training courses, but you will actually have an entire transcript of the trainings that he has had since being a law enforcement officer, going all the way back to 1999, I believe, when he went to basic training. You will hear from some of the witnesses who were at the hospital following the shooting, where John Mattingly had been taken. And the defendant went to the hospital. So you will hear from some witnesses who engaged with him at the hospital. You will see photographs that were taken by the
40
crime scene
caliber
unit
is
inside
10
apartment 4
millimeter in
as it
diameter,
processed
one
the
more
scene.
millimeter than a 9.
The body of Ms. Taylor will be in one of the photos at the end of the hallway. At the very end of the hallway, directly inside this door, looking straight ahead, is the hallway. And at the very end of the hallway, on the floor, is the body of Ms. Taylor, hit by return fire of those detectives in the doorway who were returning fire after Mattingly was shot. So I ask you to pay close attention to the testimony and keep in mind, what are the circumstances here under which this defendant acted? What are the circumstances which exhibited extreme indifference to human life? Starting with the gentleman upstairs. What was his reaction to that? How did that impact everything that followed? The circumstances of this crowded apartment building. Many, many people in this building. Starting with Mr. Sarpe and ending with Cody, Chelsea, and 5-year-old Zayden. Thank you.
Okay, so that's the end of the state's opening. Frankly, I don't know if she had other charts or demonstrables other than what she had there, because that was extremely disjointed and unclear. And let me see if I have the. I do have it. I'm not sure if I opened it correctly. Let's see. I have the defense open here. It's only 10 minutes long. I wonder if I can do it like this. Okay, I can do it like this. I don't know. I mean, the way you described it, Nate, was much clearer. I don't know if she had other demonstrables, like a floor plan of the apartment or something that the jury could see that I couldn't see. But the way she was describing it, absent that, was very unclear to me. I would not have understood what had actually happened, but for your insight.
Yeah, that's actually maybe a bad thing, because the way she explained, that's the way the jury's going to understand it. So, and if you who are an expert in this field, if you're confused on it, just imagine those poor jurors.
I just don't know if she might have had like a poster board with a floor plan, that she was pointing her laser at, and if you could see that, maybe it made sense, but it was really unclear to me. But the way you described it was very clear. So if we imagine that the officers are firing from left to right through the doorway and the bad guys firing back from deep inside the apartment, not visible through those sliding glass doors, nobody is visible through those sliding glass because no one's there, and he's shooting through the glass. Reasonable mistakes are excusable in the use of force event, but they have to be reasonable, which means they can't be speculative or imaginary. They have to be the result of the application of your powers of reason to actual evidence, things you actually see. And if you mistake something, if you saw somebody and they were holding, I don't know, a broom, and in the heat of the moment, you thought that looked like an AR, that might be a reasonable mistake. If you're seeing nothing, and you're just shooting through the window, that does not look like a reasonable mistake anymore. That looks like an unreasonable mistake. And an unreasonable mistake in the use of a deadly weapon is almost invariably recklessness.
Yeah, but just to be clear, she got in front of the bad fact. He's saying that he saw someone with an AR-15. Now, obviously, there was no AR-15 there, but he said he believed he saw someone with an AR-15. He heard the shots in the commotion, so he's responding to what he believes is a perceived threat. He sees two people go down, he looks, then he thinks he sees something, he fires. So that's his defense. But and you're right, I think he's going to be hoping
that's enough.
He's hoping that I was mistaken, but somebody was shooting, and in the heat of the moment, you got to forgive me. I looked into it, and I saw what I saw, even though technically there was no one there. There's absolutely no one could be there because all the fire was coming from the whole of the room.
Right, but to my mind, there's really three scenarios, right? There's actually someone there with an AR, or there's actually someone there that could look like they have an AR, and that would be a reasonable mistake.
Yes.
Or there's nothing there. And if there's nothing there, it doesn't look like a reasonable mistake. It looks like an imaginary perception or speculative perception. But you're to have a reasonable mistake, there has to be something you're basing the reason on. There has to be more than zero. It's just like when I tell people, listen, when you're acting in self-defense, you can't just say, well, I'm going to shoot that guy because for all I know, he has a gun, or for all I know, he has a knife.
Yeah.
You can't imagine the threat. If the guy's reaching for his waistband as if he's reaching for a weapon, and that's consistent with some threat of a weapon, well, it doesn't matter really if he has a weapon or not. He just presented as someone who does. That can be enough. But you can't just imagine it or speculate it. That's not enough for a reasonable basis for being in fear of anything.
Yeah, agreed.
But let's hear. We got 11 minutes of the defense opening. So let's see what this defense attorney has to say.
I'll bet you $1 to be better than the prosecutors because she's
So this guy's name is Stu Matthews. He's already better.
We can't see it. It's not on StreamYard.
Oh, he's not on stream. God damn it. So bad at this.
You're like he's already better. I'm like, I wish I could hear it.
Okay. So bad at this. All right, let's try it again. I don't think I have a speed adjustment here, but I don't think I'll need it. Oh, I can adjust it, but let's see. He sounded pretty normal speed. It's only 11 minutes.
Can you hear any sound? Because we can't hear any sound.
Oh my God.
Would you have to just take the window off and then click that little box that says share sound? When you do share audio, there should be a little box in the lower.
It was checked already. Damn it. All right, let me see. Share screen. Share this. Oh, man, that was okay. One more time, folks. Third time the charm. Let's see.
I can hear it.
You wish to present an opening
I do,
statement?
Your Honor. Thank you.
Got it.
May it please the court?
Yes.
Ms. Whaley, Mr. Finke, ladies and gentlemen. First of all, we finally have made it. We've been through this jury selection process.
Yeah, he's better already.
You all, 15, have been selected from a large group, and we've determined that you're the ones that are most suitable and qualified to sit on this jury and decide the issues at hand. As Judge Smith indicated to you, what I say in my opening statement and what Ms. Whaley just told you is not evidence. A lot of people refer to opening statements as opening arguments. In fact, that's a total misnomer. It's an opening statement. An argument is made at the close of the case after you've heard all the evidence, and we try to sum up what we think it has shown. The opening statement, as the judge indicated, is our opportunity to kind of provide you with a roadmap of where we expect the evidence to go. We've just spent, I'm not sure how long, listening to Ms. Whaley explain what she thinks the evidence will show. I could go on for another 2 hours filling in gaps that she did not present or providing you with further information. I'm not going to do that because the evidence that you're going to hear in this case is going to come from that witness stand and from any exhibits that are presented to you. You alone are going to decide what this case is all about. But just to begin with, ladies and gentlemen, the charge here is wanton endangerment in the first degree times 3 counts, as Ms. Whaley just explained to you. The Commonwealth's position is, and you just heard Ms. Whaley tell you, that Brett Hankerson was present at that scene and about everything he did was wrong and amounts to wanton endangerment. It adds up to wanton endangerment. The path that we are choosing is, well, first of all, the evidence is going to not be disputed too much by us with what Ms. Whaley just said. There's a lot more to fill in the gaps, but basically there's not going to be any dispute about the evidence. This is not a case of, hey, they've got the wrong guy sitting in here or somebody else did it. Brett Hankerson is the one that's charged. He's the one that fired the shots that are the subject of this case. So that's not an issue. The issue is what was the reasoning behind his firing those shots?
Yes, 3 counts
Ms.
because
Whaley
there were 3
indicates
people
that his-
endangered.
His interaction with Mr. Sarpay up on the balcony that was up there, was there something wrong with that?
But normally, even if
She
convicted of
indicates
all
that he
3, he'd
couldn't
serve them
have seen
concurrently.
what
It would be
was
unusual for
was
it to
going
be
on
sentenced
inside the door
consecutively.
once it was breached. She doesn't
Yeah,
know
highly
that.
unusual.
And you're going to hear, ladies and gentlemen, I assume from the witness, from the other, there were 7 total LMPD officers out there at Breonna Taylor's apartment to serve that search warrant.
Because it was
And you're
effectively
going to
one
hear
act.
from at least probably 5 of them, I think. I'm sure one is not going to testify. You're going to also hear from Brett Hankison when it's his turn. But through hearing from those officers, you're going to discover
Has he testified
that
yet?
this scene was total
No, they said he's
chaos.
gonna. Well, I'm not sure.
And
I
just
I don't believe so. Because that would have been in the news.
Unbelievable, chaotic
watch it.
situation, and nobody, they all have about the same recollection of what occurred, but everybody's got something different, and people don't know where each other were.
No, they're still on case in
So-
chief.
Ms. Whaley telling you definitively that Mr. Hankison was out of the picture and couldn't see in that hallway when that door was breached is not accurate. And you're going to be determining the facts, but Brett Hankison's going to tell you that when that door was breached, he had a straight shot in that hallway. He saw the muzzle flash from the gun that was fired at the officers as they breached that door. His perception of it was that it was an AR-15 rifle. Ms. Whaley said there was no AR-15 rifle in that apartment. I don't think there's going to be any evidence to establish one way or another whether there was. The evidence is going to be that once that shot was fired and the officers returned fire, the search warrant that they were there to execute to begin with was never served. The shots were fired. Breonna Taylor was killed. SWAT was called in to take over the scene after Brett Hankison successfully assisted in calling the shooter out of the apartment without any harm coming to him. Once SWAT arrived on the scene, they took over and they turned it over to the Public Integrity Unit, which conducted the investigation of the shooting. That nobody ended up serving the search warrant that the police were originally there to serve. So
That's true.
We don't know whether there was
They
any.
never searched the
contraband in
apartment
that
at all?
apartment.
Yeah, they
As a
never
crime
searched the
scene?
apartment.
And
After
what
the
kind of
dead body, they
contraband
never
there may
searched the
have been.
apartment. They
I
just
believe
policed
the
the
evidence will
body.
show that sometime
But
Well,
you know what?
presumably if there was an AR on the
March the
floor, they would have
13th,
recovered it.
in the
They
day
recovered
after
the-
this all occurred,
Yeah, they recovered the gun and the
the
bullets, but they
family
didn't search
was
the apartment.
granted access
And
to
it
the
shows you-
apartment unaccompanied.
It shows you one thing though too. The
and
news
there's no
media was
non-
using that to say that hey, no drugs were found in the apartment to make it seem like they searched and no drugs were found.
Right.
But come to find out, they just didn't search it because they were like, we messed
Right.
up. So we're not, you know,
The neighbors had a good weekend.
yeah. So
and what kind of contraband there may have been. I believe the evidence will show that sometime later on March the 13th, in the day after this all occurred, the family was granted access to the apartment unaccompanied, and there's nobody knows what could have happened.
Well, it doesn't
within
really
that
matter
apartment.
if there was
You're
contraband
gonna
there or
hear
not.
From
for purposes of this case.
FBI agent Ziegler about some shell casings that he examined besides the shell casings recovered from what the police fired. And I believe that there could be some doubt about whether or not Detective Hankison could have in fact seen an AR rifle. In any event, ladies and gentlemen, be that as it may, no matter what the evidence shows, Detective Hankison returned fire. And you have to understand, I think everybody that was out there is going to tell you that this entire incident, after the knocking and announcing had occurred, and after the breach had occurred, the entire incident lasted from anywhere from 5 to 15 seconds. Nobody had a stopwatch and timed it exactly, but it was all instantly. Officer Mattingly was shot. He returned fire. Officer Cosgrove was next to him. He returned fire. And Brett Hankison slipped around the side, as you saw on the photograph that was up there, and he returned fire in the direction of where he had seen the original shot come from within the apartment. He was attempting to defend and save the lives of his brother officers who he thought were still caught in what they call the fatal funnel in that doorway. And what he saw was he was responding number one, to the original shot. And he also will tell you that he saw muzzle flashes, which probably, as it turns out, were return fire from Cosgrove and Mattingly. But he was firing in the direction of that, as he was taught to do. You're taught to shoot until the threat is stopped. You're obligated under the
Can you pause it?
the operating procedures of the LMP.
Yeah.
If that's true, what he just said, he was actually shooting in the direction of his fellow officers, because they were the first person shot once and there was no more muzzle flashes. If he's shooting toward the direction of the muzzle flashes, he had to be shooting toward the other officers. He couldn't have been shooting toward the guy because he was on the floor. He only made one shot.
Yeah. It's yep. I mean, there would be no way for him to know, right? I mean, because he couldn't tell. And if you can't tell if you're shooting at your fellow officers or at bad guys, you shouldn't be firing those rounds.
And that's what makes it reckless, because he's shooting at, he's essentially, that's what this guy's saying. He's essentially shooting at the fellow officers. He's the one putting them in danger.
Need to defend yourself, your brother, sister officers, and citizens. And that's exactly what Brett Hankison was doing in this situation. I think after you've...
Although, ironically, you want to bet that if Breonna Taylor had not died, not as a result of his gunfire, but almost incidentally to his use of gunfire, we never would have heard about this case.
Nope.
Right?
Heard all the evidence, rather than go down the path that Ms. Whaley wants you to go down and find him guilty of wanton endangerment 3 times over. You're going to go down the path that we suggest you go down and find that he was justified. His actions were reasonable and justified given the chaotic situation he was in. And we're going to hear from a number of officers, I believe, who are firearms instructors and range instructors, who are going to say that there are certain rules that you have to follow when you're discharging a weapon, whether you're a police officer.
Now, this is something I want to ask you, because I know you're a firearms expert. Well, at least I consider you a firearms expert. From my understanding, when we were trained, they always trained us. If you can't acquire the target, well, first it was know what's in front of your target, know what's behind your target, and acquire the target, right? So if I don't know what I'm shooting, I can't shoot blindly, because that's reckless endangerment. They literally tell you that's reckless endangerment. And if I got a whole bunch of school kids behind you, I can't fire. And if you got a hit hostage. So is that true? Like if right now he's making the argument that as soon as you hear gunshots, you can fire back. And when we were trained, that just isn't true. So I'm not sure, because I know you're more experienced with the competitive shooting. Isn't that true in your world too?
Well, you'd have to have some reasonable basis for believing you're engaging a threat. I mean, the phrase engage a threat until it's neutralized presumes you've identified a threat to engage. You can't just fire blindly without knowing whether or not what you're shooting at is a threat. Now, there are obscure, like, edge cases where some bad guy's kicking in your front door and it's coming off the hinges, and maybe you can shoot through the door before he gets in, because the only explanation is he's on the other side of the door.
Yeah.
But absent some edge case like that, you can't just say, well, I guess that's a threat, and shoot at it. You have to know it's a threat. And if you're engaging that unknown threat and you miss and you hit a bystander, well, that's one thing. But if you don't have any reason, application of the powers of reason to actual evidence, not speculation. If you don't have reason to believe you're engaging a threat, then every shot you fire is arguably reckless.
All right. Yeah. They have an uphill battle, it seems like.
We aren't going to dispute any of that, but the officers go through training, and I'll tell you.
Now, I mean, he's saying that this officer could see down the corridor, could see where the bad guys were shooting. So I'd really want to see, where he was standing, a floor plan. I mean, that should be pretty easy to either demonstrate or not demonstrate, either way. But the way the prosecutor was talking, the bad guys shooting were deep down the hallway, would never have been visible to him. That's one scenario. That's bad.
Yeah.
Defense. Or maybe they were, sufficiently close to being seen that when they extended their gun, you could see the gun, or you could see the flash on the walls, or I don't know.
The way the apartment is kind of set up is that where the cops were at, it's like the long hallway to the back bedroom, to the first bedroom. But then where Hankerson it's like an L shape. So he's looking into the apartment, but he's looking into another bedroom.
Right.
And through that bedroom, you can see like the hallway to the other bedroom. So it's like a long hallway. If you go right, it's one bedroom. You go straight, it's another bedroom. So he couldn't see Breonna Taylor and them because they were back by the other bedroom.
They were
So
off
his
to the right.
Yes, so his
Yeah.
shots are just going straight through the hallway, and he's seeing the muzzle flashes from the cops in the door shooting back.
Yeah.
So he's saying, okay, I see muzzle flashes, which is different than I saw a guy with an AR, which he first said. I
Right.
see muzzle flash, so I'm firing at the muzzle flashes, which are his own people. So that's where now you're saying, well, is it reckless? Well, he was actually shooting at the cops. So
Yeah.
I don't know.
Doesn't look good.
Yeah.
The one thing that none of these people are going to say is that they are trained under circumstances such as existed on March 13th, 2020 in Breonna Taylor's apartment. And again, as I said during voir dire, this case is not about the death of Breonna Taylor, but in fact, it's totally about that, in a sense that that's what started this whole situation. We're concerned with the 3 occupants of apartment 3 who were not injured, and were not even on the radar as far as Brett Hankerson was concerned. Ms. Whaley told you about the briefing that the officers attended before they went out to Springfield. And I'm going to fill in, I don't want to get into great minutia detail, but there were 2 separate briefings. There was a number of search warrants that were going to be served that night, was the intention. SWAT was part of one briefing, and the officers who went out to Springfield were part of a different briefing. Nobody in the briefing that was held with reference to Springfield ever mentioned apartment 3 or the layout of the building. These officers went in there, had no idea what they were getting into. And part of the reason for that was that the other search warrants that were going to be served that night were for places that were well known to the police and well known to contain guns and drugs.
But when you pull
Breonna
up to the
Taylor was
apartment
kind of
building,
a
you know it's an
peripheral
apartment
part
building.
of this whole deal, but she was tied into it, and they had a valid search warrant to go there. But it was determined, and it was issued, as Ms. Whaley said, as a no-knock warrant. That means they can just go up and ram that door and go inside. But somewhere along the line that night, it was determined that Breonna Taylor was not a threat to anybody. They didn't think she was a threat to anybody. It was thought that she was living alone. She didn't have kids. She didn't have animals. Nobody thought there would be any danger there. And so I think that somebody dropped the ball, and there wasn't as much preparation done in the search of her place, which is what led up to the shooting of John Mattingly, and ultimately to Detective Hankinson firing his rounds through her apartment that went into apartment 3. All of that happened instantaneously all together. And I think, ladies and gentlemen, after you've heard all the evidence, you're going to determine that Brett Hankerson was justified in what he did, and everything he did on that scene out there before, during, and after the shooting occurred was logical, was reasonable, was justified, and made total sense. So I would ask you to keep an open and
Well, that's
clear,
what it needs to
close,
be.
and pay close
Those 3
attention
things.
to this case and to the evidence, because that's what's going to come from that witness chair and from the exhibits, not what I've just said or not what Ms. Whaley said. Thank you.
All right. So that's the defense.
So how you feeling?
It doesn't feel great to me. I'd love to, I really need to see a floor plan and see identified in that floor plan where the parties were located. Because if there's not even a prospect that you could actually see the people you thought you were targeting, then you were not targeting actual threats. You were not even misunderstanding a threat. You just couldn't see what you were shooting at. And it's hard to think of a clearer definition of recklessness than that. So
Sorry,
it doesn't look good, but I'm going to look forward to a floor plan. If I can, I'm going to try to catch this guy's testimony on when the defense presents its case in chief, just so I can, absolutely say I heard his side of the argument. But that floor plan is going to be pretty decisive.
Yeah, I think that's where it's going to be. Hold on, I'm gonna share my screen because I've pulled one up. I think I have it. Breonna Taylor, here it is. I think I have a floor plan right here. They did a reenactment, and let me see if I can just. I gotta download this stupid thing. I'm an old man now. I keep saying it's like this technology.
And folks, the police, they don't have enough bodies to do days of surveillance on every. That's not real life.
Where's it at? No, this is not a kid. 16, 17.
Somebody is screaming. Is that on your end? Is that a TV or something?
Oh yeah, my kids are watching
Okay.
this YouTube. Hey, Aubrey, can you turn that down? My 5-year-old. I'm sorry. Let me turn my microphone so you don't hear the screaming in the background from another YouTube channel. It's funny because now we don't even watch TV anymore. They just watch YouTube. I'm like, oh my God. We've even stopped paying for cable.
Yeah, we stopped a long time ago.
Yeah, it was just like it doesn't even work anymore. All right. This is what it seems like. This is where the cops, the entry point. This is where they were at, and this is Hankerson right here, shooting through here.
Oh, okay.
So they're over here. Hankerson's here shooting.
Oh, who's this?
So up here at the upper left hand, where you see all those numbers.
the bottom middle. This little window here.
This is Hankerson on the bottom.
Both places.
Yes, he's further back. He's shooting toward. This is when he said he's shooting toward the muzzle flash.
Yeah.
And I'm thinking he's shooting in both directions. So he's shooting this way and this way. The cluster shots from everybody first started here.
Yeah.
And Breonna Taylor and them are back here.
All right. So maybe he did see him for these shots.
It's possible, but he's saying he saw muzzle flashes. So he shot here.
And those must be the shots that went to the next apartment, right?
Correct.
The vertical ones on the left, right?
Yeah, and you see them go all the way through the apartment, and then you see these ones go into the bathrooms. So Breonna Taylor was where this T16, and this is where they were at.
Right.
So he's shooting into this empty bedroom, and then across. I'm assuming he first started shooting back toward the empty bedroom, and then saw the muzzle flashes, and then shot back toward the muzzle flashes.
Right.
Which was dangerous.
Yeah. So these shots on the right, the vertical lines on the right here towards 14 and 16, they may have been legit.
Yes.
I presume the door was open, or there'd be bullet holes in the door. We would know. But then these shots on the left here, the ones are, those are the ones that would be difficult to justify. I mean, either he didn't see any target, or he was actually shooting at his fellow officers, as you say.
And now, if you're saying that, because he's saying I saw a guy with an AR-15, that's why I shot. So if you saw an AR-15 guy with an AR-15, was he over here? And if you did see him over here, then why'd you still shooting over there? Unless he thought there was multiple targets. Right. So he's got it's an uphill battle for him, because there's a lot going on here. But again, his attorney, he could be confident that he has something better. But
yeah, I'd like to if you can send me that image, Nate, that would be great.
Sure.
I'd like to hear the defendant's explanation of why both those series of shots would qualify as not reckless. I mean, the ones on the right, I'm open to argument. That was at least in the direction of people who were presumably firing at his colleagues in the doorway. The ones on the left, again, there was nobody there, or if there was anybody there, it was his fellow officers. So that was
he was the visual reenactment. I'm linking. I'll send you the link via Twitter. But here's, because they did like a whole workup on it. So can you see this?
Yeah. Let's see.
So the white is the first shot, and then the last shots are the Hankerson shots. So this is Breonna Taylor's boyfriend shots.
Yep.
Here's all those other shots coming in, and that's Hankerson.
All right. So it looks like first he does the shots on the left, and then the shots on the right.
Yeah. And then the problem is that this door is open, so he shoots through these doors. So first. Right. Yeah, so first it's these shots and these shots. No, actually, if he shoots to the left, he shoots toward the cops first.
Yeah, right.
And then he shoots toward where the gunshot came out. So so he couldn't have seen anybody if he's shooting this way first.
Well, he would have shot there. Then he may have seen movement through the window and decided, shit, that's where the bad guys actually are.
Ugh, it's gonna
those I would arguably, there could be a reasonable basis there for that second series of shots through the doorway. I'm amenable to argument there. The ones on the left I would find very difficult to justify.
Yeah, he's unless.
So who did this? Who did this?
This is a reenactment by this guy on Twitter. He's a crime scene analyst. I'll send you the link right now so you can.
Yeah,
see
I'd
it.
appreciate that.
Yeah,
I mean, I don't know him, so I don't know if he's making shit up or what. But
Yeah. No. It's just, trust me, evaluate the evidence all by yourself. You know, if I send you a link, and if it's BS, please tell me it's BS, because I don't want to be using something that's wrong.
Yeah. Well, I mean, the only way to know really is to compare it to what's actually shown in trial. You know,
Yeah.
Otherwise people are just making shit up. And in a politically charged case like this, there's obviously a lot of stuff being made up.
Yeah. But I think Hankerson's biggest problem is that he himself, what he said he saw was incorrect. The first sortie of bullets were going actually toward the cops, and I think the last sortie of bullets could be good, but they happened after those last flurry of bullets toward the shooter. They were so late in the game, you know, there was no more fire coming from that.
It could
that
be
location,
right. I mean, they only ever fired one shot.
Yeah.
So again, I might be willing to give the benefit of the doubt there. You see, that's where the bad guys fired from. You still see people moving there. All right, not a great judgment call, but maybe reasonable under the circumstances. Maybe you're hearing that your partner got, you know, shot and is bleeding out, and, you know, heightens everything up. But that would be a reasonable mistake, or maybe reasonable imperfect judgment. The shots fired closer to where the police were, closer to the entry door, strike me as extremely troublesome. But that's great. Yeah, if you can send me that animation too, that would be interesting.
I DM'd it to you, so you see the animation. They have all the reenactments. So, and then there's also some body camera footage, but you know that you'll see where they were explaining it. And even a SWAT team guy, he came. He was like, "Well, listen, if you really didn't see it, you know, then why did you return fire? So why'd you shoot so many times? That type of thing." But that's probably going to be all when they have them testify. But at this point in time,
there were a shitload of rounds fired. Holy crap!
But
I'm surprised everybody didn't die.
But hey, if you know, think about it though. You're right. You know, you bust down the door and a shot comes at you. Of course, you know, if you're there, you got to let it go. You know what I'm saying? Because and that's the thing I think sometimes that upsets with the Black Lives Matter movement with this particular case. What did they expect the cops to do? The cops are literally taking fire. One has been shot, and they're saying that they shouldn't fire back. Now, don't get me wrong, Breonna Taylor, she shouldn't have died. Okay, I understand that. But at a point, we can't just expect the cops to sit there and just take fire and not do anything, right? It's like they were there executing.
Right. And that's why those guys weren't charged.
Yeah, but you know, people marching the street saying they should be charged.
Well, I know,
right?
I know.
And that's just unreasonable at that particular time. The cop literally was shot. You know, what more could he have done? So, well, we'll see.
All right,
we'll
Nate.
see.
Well, folks, I think I'm gonna wrap up. I was gonna do the interview with the defendant that took place a couple weeks after this event, but I don't have it processed yet. So, and it's an hour all by itself. So I think we'll do that as a separate show. Give everyone their Sunday back. Nate, thank you very much for joining me. You're always welcome, always appreciated, brother. And to everybody else, I'll say, remember, if you carry a gun, so you're hard to kill. That's why I carry a gun. So I'm hard to kill. My family's hard to kill. Then you also owe it to yourself and your family to make sure you know the law, so you're hard to convict. And until next time, folks, I remain Attorney Andrew Branca for Law of Self-Defense. Take care.